Hi everyone, good evening once again. I hope I am audible now. Am I audible to you all? Can you guys please confirm in the chat box like I'm audible to you or not audible at all? Okay, great. Thank you, Purushottam, for confirming that I'm audible. Um, Okay, some of you are still saying that I'm not audible, so I'm just getting confused. Like I have rejoined the session now. So can we have majority? Like if I'm audible, at least give me some reaction that I'm audible to others as well. Okay, I'm audible. All right. Thank you very much. Okay, so welcome back to the second session of live masterclass on non-compete clauses. This is a two-day live masterclass session. So we discussed about non-compete clauses in yesterday's session where we discussed their enforceability in India and international laws related to non-compete clause as well. If you are someone who are joining the session for the first time, then we go live every Friday at 6 p.m. discussing about new topics related to contracts. So you can subscribe to our channel to stay updated with such more content regarding contracts and corporate law. Okay, now will be Okay, so if you haven't attended yesterday's session, you can just go back to our channel and check for yesterday's session. You can go through the session. I'll be just giving a brief sum up of what was discussed yesterday. And then today we'll be learning how to draft a non-compete clause. Okay. So till the time I'm sharing my screen and everything, kindly let me know like from where you are joining, what you're doing currently in the chat box. Please let me know. And I'm hoping that you guys will be interactive throughout the session because this is going to be a very much interactive session where we are going to learn new things with regard to drafting of non-compete clause. Towards the end, we'll also be checking, going through one non-compete agreement as well. Okay. All right. So till the time I'm just sharing my screen, let me know from where you guys are joining and how many of you had attended yesterday's session. Okay. All right. Okay, so I'll just brief up what we discussed in first session. We talked about what is non-compete clauses. So I'll just explain it to you in very brief. You can refer to the previous session by going to our channel. So we discussed about the meaning of non-compete clause. It's a clause that is majorly entered between employer and employee when employees are entering into business or when businesses are getting sold. For example, whenever mergers and acquisition deals happens, that time non-compete clauses are particularly inserted in your agreement. The purpose of these clauses are to restrict your employee or the previous business owner from starting similar type of business or joining the competing company. Okay, that's the major purpose. So let's make it easier for you to understand. Just consider that this particular clause is inserted in your employment agreement where your employer is restricting you from joining a competing company or starting your own business in the similar field. So for the same, let's take an example that you were working as a chef in a restaurant where you worked for a period of 6 months and you had entered into like in your employment agreement there was a non compete clause. Okay, that restricted you from starting your own restaurant within the radius of 10 kilometers for a period of 1 year. That means for a period of 1 year and within that area of 10 kilometer you are not allowed to open your new restaurant. Okay, now in this scenario the employee, the chef who started working in that restaurant, is not allowed to start his own new restaurant within that 10-kilometer area or during the period of 1 year. After 1 year he is allowed to start his own business. He is also allowed to like whenever he's starting his own business, he's allowed to start it beyond that 10-kilometer area, not within that. Okay, so with this we discussed like throughout what is the importance of non-compete clause, whether they are enforceable in India or not, which sections apply to the same. We also discussed about section 27 of Indian Contract Act. So I'll just sum it up over here because we had a very lengthy session yesterday. Please refer to the session 1 of yesterday's recording. You can check it on our channel. Okay, so today's topic is going to be about like why how to make non-compete clauses enforceable, because we discussed that these type of clauses are very complex in nature. We have to consider a lot of things before drafting these clauses and also while entering into these clauses. Many people have signed these particular clause once they have joined the company. Mainly multinational companies include these type of clauses in their employment agreements to restrict their employees from joining the competing company. So companies like Infosys, Wipro, TCS, all the multinational companies include these type of clauses. But very few employees are aware of the fact that these type of clauses are actually challengeable in court. They are not that much effective. They can be held effective only if they have been drafted keeping certain specifications in mind, like they have been drafted keeping reasonableness in mind. Okay, so that's what we are going to discuss today, like how to draft a non-compete clause to make it enforceable in court of law. Okay, can I have your reactions or thumbs up, anything please, so I can get to know, like, you guys are up with me now, I can proceed ahead. Can I have your reactions, please? Okay, great. Thank you. Now let's start with today's session. If you haven't subscribed to the channel, make sure that you have subscribed to it. And also do let us know in the meanwhile, like on which other topic you would like us to discuss upon, like conduct the sessions on. Okay, do let us know. Okay. All right, so let's start. Today, we are going to start with a brief case study. We are going to just briefly discuss major case laws related to non compete clauses. Then, we are going to do some analysis on the same. Okay, so on your screen, it's visible. We'll be discussing about four major case laws is related to non compete clauses. So, the number one case law is Niranjan Shankar Golikari versus Century Spinning and Manufacturing Company Limited. In this particular case law, what happened, Niranjan was working in Century Spinning Company, and during that time, he was working over there. Okay, but he was not allowed to work with any other competing company at the same time. If you are working in one particular company, that's an obvious law that you're not supposed to work in some other particular company as well, right? So to restrict you from joining any other competing company's business, non-compete clauses are also included in your employment agreement. So in this particular case law, the court held that a non-compete clause during the course of employment is valid. So if a non-compete clause is prohibiting you from joining any other company during the course of your employment, when you are working there as an employee, you haven't resigned from that company, in that scenario, the clause will be considered as completely enforceable and valid. Next, in the second case law of Superintendents Company of India versus Krishan Murgai, in this particular case law, it was held that post-employment non-compete clauses are void under Section 27 of Indian Contract Act. That means that you're not allowed to restrict a person once they have resigned from your company to not work in any other company. If you're doing that, that will be considered as a void agreement, as it is restraining a person from doing their trade or business, right? It is against Section 27 of Indian Contract Act. Next, in Tapas Kanti Mandal versus Cosmos Films Limited. In this particular case law, it was held that a post-employment non-compete clause preventing the employer from joining competitors was unenforceable. So, same thing, it was held that if you are working in a company, that time you can be restricted from joining any other company. But once you have resigned from the company, post-employment, okay, at that time, the if you are still being restricted from joining any other company, the non compete clause will be considered as not enforceable. You can challenge it. Okay. Then we have Diljit Titus Advocate versus Alfred A.D. Adbury and others. So in this particular case law, what happened? One of the employee who was working under an advocate left him and started using his data in getting more employees. Like he started his own practice with the client data he had when he was working under advocate. So he used that data. So in this particular case law, the court held that while non-compete clauses are unenforceable, post-employment non-disclosure of confidentiality information can still be enforced. means that you can be restricted from not starting your own business or not working for competitors, but the confidentiality thing that still remains upon you. That means you are still being restricted not to use the data which you got access to when you were working in that company. Okay, so basically, confidentiality refers to the secret information of a company. The client data, vendor data, the marketing strategy, all these are refers to as the confidential information of a company. So, non-compete clauses are valid when they are restricting you during the term of employment. They are not considered as valid when they are restricting you post employment. So, let's analyze whatever we have learned from all the particular case laws. First is reasonableness. Courts assess whether the restriction imposed by a non-compete clause are reasonable in scope, duration, and geographic area to protect the employer's legitimate business interest. So now consider that the non-compete clauses are mainly drafted keeping in mind to protect the interest of the employer. Okay, but still we have to consider the rights of the employee as well, because both the parties are getting affected because of it, right? Both the parties were playing their roles and obligations in the contract, and now even if we are drafting a particular clause, we need to make sure that the clauses are fair in terms, they are not unfair, because we cannot ultimately restrain a person from not doing job at all. What if a scenario is there, a person is finding a job in competing company only? If you were an employee of Infosys, now you have left Infosys, but after leaving Infosys, the ultimate competitor of Infosys is Wipro. You're finding a job in Wipro only because your skill sets and experiences match the job application in Wipro only. So you will not say no to that opportunity just because you have signed a non-compete clause. That will be against your right to livelihood as well, right? So what will you do in this scenario? You can challenge the non-compete clause on the grounds of that it is not reasonable. You can and the courts will ultimately held the discussion that it is against your right and it is not reasonable in nature. Okay, next is legitimate business interest. Companies can only restrict you from not joining any other competing business or starting your own business if the legitimate business interest is getting affected. So, in our particular case law of Diljit, in that scenario, the confidential information of the parties were getting affected, right? In that scenario, that confidential information was getting affected. So, you can restrict a person from not sharing or using your confidential information, but you cannot restrict them from starting a similar type of business. Even if you are restricting them, that should be along with a specific timeline. You cannot restrict them throughout their lifetime. There should be a scope, there should be a specific duration or geographical limit within which you are restricting them from starting their own business or joining a competitor's company. Then we already discussed employees' rights to livelihood, right? You cannot restrict them because ultimately everyone needs to feed their tummy. So how they're going to do so until and unless they are not able to get a job, you cannot restrict them from doing so. So that will be unreasonable, unfair in nature if you are restricting someone from not finding a job in any other competing company. Post employment versus during employment, this is a very very important thing. So with the case analysis, we are able to understand that if we are restricting an employee to find a job in or indulge in any business activity of similar nature, means if I am restricting an employee to join a competing company or starting a similar business, मैं अपने एम्प्लॉय को कंपीटिंग कंपनी ज्वाइन करने में और सेम तरह का बिजनेस स्टार्ट करने में रिस्ट्रिक्ट करूंगी ड्यूरिंग द टर्म ऑफ एम्प्लॉयमेंट व्हेन ही इज वर्किंग विथ मी. At that time, the non-compete clause will be considered as valid. Okay, but once the employee has left my organization, if I'm still restricting him from joining a competitor's company or starting his own business, that is for infinite period without any geographical boundaries, in that scenario it will be considered as unenforceable. Okay, next is specific restrictions. Non-compete clauses can be considered as enforceable if we are including specific restrictions, like when it comes to your sharing confidential information or non-solicitation, all these things. So don't worry, we'll be discussing about these terms in detail as well. Okay, now let's once again understand when non compete clauses are enforceable and when they are not enforceable at all. So, we did a short case analysis, we discussed about case laws as well. From that, we have taken out points, clear points like when they can be held enforceable. During the term of employment, means I'm restricting you not to join any competing business or start your own business or indulge in any other freelancing activity as well relating to similar work which you're doing during your term of employment. Let's say that during your term of employment, okay, let's consider that you're a teacher, okay, working in an organization. You are teaching contract law. We'll go with the same example. You are teaching contract law, that and your term of employment is 1 year. Now, if the non-compete clause is included in your employment agreement, in this 1 year you are not allowed to start your own practice, own separate practice, or to join any other competing company. So if someone who is currently working with Ledroit starts working with any other competing company under same job role, explaining same thing, everything, that in that scenario he will be conducting a breach of contract. Or if the same person starts his own business providing the same services, that scenario as well, it will be considered as breach of contract, okay, because he was restricted during his term of employment not to start this thing. Next is in connection with sale of business. So majorly when companies sell their business, in scenario of your acquisitions, mergers, partnership, whenever the businesses are getting sold out, you are giving them a money, and in exchange of that money, you are purchasing their goodwill, reputation of business, right? So let's go with any other example. I'm not coming with any company right now. So let's take XYZ sold his business to ABC company. Now ABC company has paid them a lot of money to purchase their business, right? Now XYZ company, after selling their business, cannot go and start their own business in the same field or with the same name. Neither they can claim their rights, because whatever rights they had, they have already sold it out to ABC company. Correct. Now, after selling their business, if they go and start again the same business in the same field, that will be very unfair in nature, because ABC company has paid them a fair price for their goodwill, for their reputation. And why do companies purchase the other company? Why do they acquire? They acquire or merge in order to eliminate competition. That means to decrease the competition. If there are two competitors in the market and I have already paid you and purchased your company, why I'm doing so? So that I can be the only person providing that service in the market, right? I want to remove the competition. That's why I have paid you and purchased your company. Now, after taking money from me, you cannot go and start a business in the same field all again. Right? That will be very unfair. So, in order to restrict from all these activities, we include non-compete clause in your mergers and acquisitions agreement as well as in your partnership agreements. Next is post-employment with reasonable limits and compensation. So, non compete clause can be considered as enforceable when they are restricting you post employment, provided they should be reasonable in nature. They should not be unreasonable. There should be reasonable limits, and during that time you should also be provided with certain compensation. So in our last session we discussed that several countries impose like non-compete clause as enforceable only when the employee is getting compensated during that time. That restriction time varies from country to country law, state to state law. So based on that state law, the non-compete clause should be complying towards that state law, right? So let's say that if the law of the country is 3 months, like beyond 3 months you cannot restrict a person from joining any other competing business or starting his own business. If a clause is restraining you beyond 3 months, in that scenario it is unreasonable in nature. You cannot restrict a person for their lifetime. There should be reasonableness. You should be specifying the time period. It can be 1 year, 2 year. Now if I'm restricting you to not start your own business or join any other company, I should also compensate you. That will be only fair then, because I cannot let you stay miserably without compensating you during this time if you're not finding any job. correct? So I should be giving you compensation. So mainly US, various states have included like 50% of the gross salary or monthly salary, 30% of the monthly salary. In this way the employee will be compensated till the time he's not joining any competitor's business or starting his own business. If these type of things are included in your non-compete clause, that time we can consider it as enforceable. Let me know if you have any query. You can drop your questions in the chat box. Okay, let me know if it's getting confusing. I'll re-explain things to you. Next is when it protects legitimate business interest. Now, non-compete clause, why we are saying that it is completely not enforceable, because this clause is important to protect the interest of the employer as well. This is just not protecting the interest of employee, we are also focusing on to protecting the interest of the employer. We are trying to maintain a balance. So with this, the employer is also trying to protect his confidential information. What if when you were working in a company, you got access to all the confidential data of the company, you got access to the trade secrets of the company. So trade secrets, I'll just re-explain once again. We already did this in our previous session. Any type of secret information, any type of business secret information that has a commercial value to it, okay, is considered as a trade secret. This type of information should not be available in the market, should be kept secret by the person having it. All reasonable methods should be taken by the same, okay, in order to consider them as trade secret. Okay, so if I'm sharing a major secret with you on the basis of which my business is being run, and if that information gets leaked out, in that scenario, there are chances that my business not be running in the same manner. It might start getting losses, or there will be a lot of competitors in the market, because now everyone have got access to that information, right? So I can protect my trade secret by including a non-compete clause. By way of that, I'm restricting you that even if you have got access to the business information, you're not going to use this information for your own personal benefits. Okay, so let's go with another example. Coca-Cola recipe is considered as trade secret. Okay, now if I had shared that recipe with you, once you're no longer an employee with us and you go ahead and start, now you have access to the recipe, right? There are chances that you can start your own company providing the same beverages using the same recipe, right? So how I can restrict you? I can restrict you by including a non compete clause in an agreement to restrain you from using that recipe. Okay, then what are the scenarios when non compete clauses are not enforceable? When they are restricting you post employment. So we discussed that even if you're including a non compete clause, that should be reasonable in nature. You cannot restrict a person throughout their life, or you cannot say that they are restricted from not joining any company worldwide. You cannot do so, right? So post employment restrictions in India are usually considered as unenforceable. If you come across any non-compete clause, make sure they are specifying the scope of it, they're specifying the timeline, they're also specifying the geographical limitation. Next is overly broad or unreasonable clauses. So whenever you are drafting a clause, make sure you're not over elaborating. You're keeping it short and simple and easily understandable, because employment agreements are not always entered between lawyers. There are various laymen as well, right, who don't have knowledge about law. So make sure non-compete clauses are drafted in simple English language. You are not making the language very much complex in nature, so that people are not able to understand. Without compensation, if I'm restricting you from not joining any other company, I should also be compensating you during that time, because I am restricting you from finding any job. And if even if you're getting a job in a competing company, I'm the one restricting you from not joining over there. So during this time, it's reasonable that I should be paying you, right? Because I cannot leave you unemployed throughout this time. Next is for junior or non-key employees. Another important thing, this is one of the bases on which non-compete clauses can be challenged in court, when usually non-compete clauses are preferred for senior level employees. You cannot restrict a security guard from joining any other company. That will be useless. It will not make any sense, right? Because he hasn't got any knowledge to about your company, private informations or client data or anything. His job role was completely different. So that will be very unreasonable if I'm making it a junior level employee restraining from joining any other company or starting his own business. So whenever you're including a non-compete clause, that should always be included to restrict a senior level or senior position employee only. Okay. All right. So, all right. Let me just take a minute to look into your questions. Whatever doubts you have, please let me know in the chat box. Right now, I'm reading out your questions. Okay. um these void agreements, Ariba, these will be considered as void agreements only if they are unreasonable in nature. Okay, in that scenario only we'll be considering them as void in nature. You That's why you have to maintain a balance between these type of things. You have to make sure that you are able to protect the interest of the employer as well as you are able to provide justice to the employee. You have to keep the clauses very fair in nature. So we discussed about when these can be enforceable. Whenever you are allowed to restrict your employee, but basically when you are allowed to restrict your employee, when they are working with you. When they are working with you, of course, you are not going to allow them to work with any other competing company, right? And if they have left your company, that is post employment, in that scenario as well, you can restrict you, but there should be proper reasonableness. It should be followed with compensation. It should be followed by your duration as well. So your duration can be period of 6 months or 1 year, and if I'm restricting you during this period, I am also compensating you to make the clauses very fair in nature. Okay, so that I am not violating any of your rights. So all these things have to be kept in mind when you are drafting a non compete clause. Okay, so now let's understand. uh okay, we'll be doing one thing now. Let's just focus on how a non-compete clause looks like. It's visible to you on the screen. Take a minute or read along with me. Okay, this is a sample of a non-compete clause. Thereafter we'll be taking a look into a non-compete agreement as well. Okay, so basically, what is non-compete clause? Non-compete during the term of this agreement and for a period of 12 months following the director's removal or resignation from the board of directors of the company or any of its subsidiaries or affiliates, the restricted period, the director shall not directly or indirectly in any manner whatsoever engage in any capacity with any business competitive with the company's current lines of business or any business then engaged in by the company, any of its subsidiaries or any of its affiliates, the company's business, for the director's own benefit or for the benefit of any person or entity other than the company or any subsidiary or affiliate, have any interest as owner, sole proprietor, stockholder, partner, lender, director, officer, manager, employee, consultant, agent, or otherwise in any business competitive with the company's businesses. Okay, so let's just keep it till here. The remaining part you can look into it, but for now, even if you are reading it till here, till company's business, that's also fine. So what we have discussed so far, that I am restricting the company's director. So how this clause is valid? The director is a senior position, right? They are senior level employee. So that is making the clause enforceable. We are restricting them during within a scope of period. Like there's a duration during which we are restricting them. That is 12 months. So there's a scope. This is not indefinite in nature. This particular clause is not evergreen in nature, right? It is not perpetual in nature without any deadline. There's a deadline that it is 12 months. So it is crossing our checklist that there should be duration, right? Then during this time, what are we restricting him from? In any manner, in whatsoever, engage in any capacity with any business competitive with the company's current line of business. So current line, that means whatever the company is currently doing. Let's say the company is into cloth manufacturing, so he's not allowed to engage in similar type of services, similar type of activity. He's not allowed to enter into that type of activity. Apart from that, he's allowed to do so. Okay, or any business then engaged in by the company, any of its subsidiaries or any of its affiliates, the company's business, for the director's own benefit or the benefit of any person or entity other than the company or any subsidiary or affiliate. That means apart from cloth manufacturing business, any other subsidiary company, whatever company the company is holding, or any or the other businesses, director should not be engaging in any activity through which he is getting his own benefits. Neither he is allowed to share the business information with any other competing company as well for their benefit. Okay. Have any interest as owner, sole proprietor, stockholder, partner, lender, director, office manager, employee, consultant, agent, or otherwise in any business competitive with the company's business. So what we are doing, we are also restricting him from not joining as a partner, sole proprietor, stockholder, even as an employee, office manager, or etc. other roles. We are restricting him from not joining any other competitive business. Okay, so in this scenario, this particular non-compete clause is going to be considered as valid. Reason being, we are restricting him from not joining any similar type of business for a limited period of 12 months only. And the position of the director is senior level employee. Okay, and then if you'll read the second part of the clause, you will be able to understand that he's allowed to hold 1% of the outstanding securities. So whatever position he had in the company, he's allowed to hold that 1% of it in form of shares or anything. Okay, he's allowed to hold it in that manner. So in this scenario, this particular non-compete clause will be considered as valid in nature. Okay, now let's understand, non-compete clauses are very much complex in nature, so there are chances they can be challenged in court of law. Mainly employees do that, they challenge in court of law on the grounds that you're restricting a person from starting their own business. That is violation of their article 191G, and that is also violation of section 27 of the Indian Contract Act, right? So on these grounds you can challenge the non-compete clause. But so what companies are nowadays doing in order to avoid these type of conflicts with regard to challenging of non-compete clause, what are the other methods or other clauses they are including in order to make these clauses valid, or in order to not to include these type of clauses, what are the other trends that we are following currently are, first is garden leave clause. So this is a new type of concept that you're mainly going to find in mergers and acquisition agreements as well. Okay, or in your employment agreements as well. So what happens in this particular clause, it's a clause where the employee remains on the payroll usually during the notice period, but is required not to join a competitor or work actively. So what happens, if I don't want to work with the organization, if they want to restrict me from joining any other company, they can say, okay, don't work for me for this period, like 3 months or 4 months. During this time, they will be paying me, they will be continue to pay me and provide me all the employee benefits during this time, and I'll also not be working during this time. Why they're doing so? In order to restrict me from joining any other competitor's business. So in the meantime, they can take all their precautionary methods, they can protect their information and everything, or whatever other action they need to take, they can take it, and after 3 months they can let me go. So what they will be doing during this 3 months time, they will be taking all the necessary data from me, whatever I was working on. They will be removing the access from all the data. This usually happens during your notice period time. Companies stop giving you work, they start taking out the data from you. Whatever work you were doing initially, they will ask you to hand over it, right? And during this time you're also being paid even when you're not working for the company, so that you are like not joining any other competitors business. Next is mergers and acquisitions. So non-compete clauses are considered as completely valid in your mergers and acquisitions deal. In that scenario, they are considered as completely reasonable in nature, because they fall under your exception of section 27 of the Indian Contract Act, that provides that the any restraint any restriction you are providing in order to, when there is a sale of goodwill or sale of business, in that scenario the restriction will be considered as completely valid in nature, right? So in that scenario, in mergers and acquisitions agreement, your non compete clauses will be considered as completely valid in nature. Third is confidentiality. Another way of protecting business information is by including a confidentiality clause in your employment agreements and in other agreements. So, the basic purpose of this clause will be to protect business information. I am restricting you from not using the data, the client data, vendor data, whatever information you had access to during the term of employment. I am restricting you from not using this data for your own benefit, neither leaking out this data outside. Okay, so I'm restricting you to not use this data for any other matter or neither disclose it to any third party. That is the purpose of your confidentiality clause. We also have separate video lectures on trade secrets as well as on non-disclosure agreement. You can check out in our channel. There are separate videos for them. Okay. Next is non-solicitation clause. In this particular clause, the basic purpose is that I am restricting you from not poaching my clients or not hunting down my clients. Okay. Or neither hunting down my employees as well. So basically, let's understand this clause with an example. You were working you were working in my company as a you were working in a marketing agency where you were in direct touch with the clients, you were directly dealing with the clients, you had access to all the business data, all the vendor data, all the information of the business. You worked in this particular company for a period of 10 years. During this 10 years you made a good contact with all the employees and the clients as well. After 10 years you decide that now you want to start your own business in the same field, in the same marketing agency you want to start it. Okay, now you have started your own business as well. Now after starting your own business you will be looking out for clients, correct? You will be looking out for clients. Now how I can restrict you that you cannot reach out to my clients with whom you were in touch with? Because if you were in direct touch with my clients, you will be having their contact numbers as well, and you can provide the same type of service to them at lower cost, and you can steal away my clients, right? So the basic purpose of this clause is to restrict you from not stealing my clients. That's the purpose of your non-solicitation clause, that bars former employees from poaching client, customer, or other employees. Okay, so this clause can also be included in your employment agreement. Next is blue pencil doctrine. So this particular doctrine is being followed in USA mainly. What happens over here is the court strikes down the area that is unenforceable in nature and lets the area that is valid to be enforceable. So let's consider if a non-compete clause is too wide in nature. Example, it restricts someone from working anywhere in the world for 5 years. A court may strike out the unreasonable part, that is anywhere in the world. I cannot restrict you from joining anywhere in the world, right? That will be very unfair in nature, and keep the remaining part of like for example 5 year, I can let it be there. Court can also let give you suggestion on how to modify this particular clause. That's why it is known as blue pencil doctrine, where the court is actually removing the a particular statement that is unenforceable or unreasonable in nature. I'm going to remove that, and the remaining part that is considered as reasonable, I'm going to let it be there and make it enforceable. Okay, so these are the trending methods that are being currently followed along with non-compete clause. How I can make my contract very much valid in nature by including separate other clauses, that is confidentiality clause and non-solicitation clause. If you are interested in learning more about these clauses, you can join our paid course on contract drafting that is starting from 1st August. Over there we'll be discussing about how to draft these clauses as well, and overall importance of these clauses along with how to draft an overall agreement. Okay, now let's take a look into your particular non-compete agreement and non-solicitation agreement. I'll be changing my screen now. Okay, just let me know. we'll be just quickly going through one of the agreement, and I'll be sharing this link with you. So don't worry, you'll be having access to this particular document as well. Can you guys please confirm if you're able to see a change of screen? Is the agreement visible to you all now? Can I have your yes or no in the chat box, please? Okay, thank you. All right. So basically, this is an example of a non-compete and solicitation agreement. If you'll notice, we have talked about this agreement is made and entered into by and between. We'll be mentioning the name of the employee, the name of the company, and from which date this particular agreement will be getting effective into. Let's just directly focus on the clauses. So this is a combined agreement. We have combined your non-compete, that is, I'm restricting you from joining any other competitors company or starting your own business. Non-solicitation, that I'm restricting you from reaching out to my clients as well. Okay, so if you are a senior position employee, director, or partner, in that scenario, I can include this type of clause and bind you throughout. So, let's focus on the term of the agreement. It says this agreement shall be effective from the effective date and will remain in force throughout the duration of your employment with the company and for a period of 1 year following the end of your employment. So, we are making it enforceable by keeping the duration as 1 year, not unnecessarily lengthy period, longer period, right? 1 year is a reasonable time. Scope of the agreement, this agreement is not intended to create a contract of employment. Both you and the company acknowledge that this does not obligate either party to a sacrifice duration of to a party to a specific duration of employment. The scope of this agreement is limited solely to non-compete and non-solicitation obligations outlined herein. So we have specified the scope of this particular agreement, that by this we are not entering into a new employment or anything. We are majorly keeping the scope limited to non-compete and non-solicitation, means not allowing you to join anywhere else and also not allowing you to reach out to any other client or anything. So sometimes companies make you enter into these separate agreements altogether. Like there will be chances that non-compete clause will be included in your employment agreement. Like in your employment agreement, along with several other clauses, there will be a non-compete clause. But majorly, you will be made to sign an overall non-compete agreement when you have got a lot of confidential information of a company, or when company wants to give major priority to restrict you from starting your own business. Okay, so this particular agreement can be made you to sign when you are leaving the company. At that time they can make you sign this particular agreement to refresh in your mind that you are not allowed to do these things, and to again revise things to you that you have signed this particular agreement, and in case you go ahead and do something against this agreement, that will be considered as breach of contract. Okay, next is it talks about non compete obligation. You agree that during your employment with the company you will not engage in any business activity that competes with the company, nor will you work for or associate with any business that is in competition with the company. So what they are doing, they're saying during your employment with the company, that means this agreement was signed at the time of employment, like when you were joining the company, at that time this particular agreement was signed. So it totally depends on the company when they want you to sign this particular agreement. If they want to emphasize pressure on you or to remind you that what are the things you're signing upon, then in that scenario they can make you sign these type of agreements altogether separately. So there will be chances that you're signing a separate non-disclosure agreement, you're signing a separate non-compete agreement, because companies give more emphasis to these topics. They want to remind you things that these are very crucial matters for them, and if you're going against these type of things, that will be considered as breach of contract. Then they have provided a clause for non-solicitation of personnel that says during your employment and for 1 year following in its termination, you agree not to solicit or attempt to solicit any employee or independent contractor of the company on behalf of another business You also agree not to encourage or induce any such person to leave or breach their relationship with the company. So there are chances, right, that one of the employee, when he's leaving the company, he can try to manipulate other employees, like, don't work with that company. I'm currently working with this company. Come and join this company. They are providing a lot of perks and things. Or you can join my own business. When I've started my own business, I can try to hunt them, saying that you can come and join my company, I'll be providing you perks over here. So I'm restricting basically someone from starting a similar type of business. I'm also restricting them from stealing my employees and my clients. Why I'm doing so? I'm doing this to protect my business interest, right? So non-solicitation of clients and customers. So again, with this particular clause, we are making it very clear, not only you are not allowed to reach out to employees who are working in my company, but also you're not allowed to reach out to the employees or clients who are working in my company, right? So this way we'll be including several other clauses all together. Now, all these particular clauses are included in your agreement, and this way your non-compete and solicitation agreement is drafted. I'll be sharing a link of this particular agreement with you. It also has got a lot of notes, whatever we have discussed with regard to non-compete clauses. You can refer to the same. I'm dropping the same in your chat box. Okay. um this particular link is also there in your description, so you can take a look from there. Okay, so I think so with that we have come to an end of this session. We discussed about non-compete clauses, we discussed about your non-solicitation clauses and garden leave clauses. Make sure you have subscribed to the channel, because we go live every Friday at 6 p.m. And do let us know on what other topic you would like us to discuss things on. This was a 2-day live masterclass. If you want certificate of this, you can get a certificate. So the session was free for you, but if you want to get a certificate, there's a course on our website. You can pay just rupees 100 to receive your certificate for attending this particular masterclass. Okay. So for certificate, you have to go and register on the website by paying rupees 100. Your certificates will be sent out to you. So that's all for today. I hope the session was beneficial for you all. Let me know how you like the session, or in what other topic you would like me to cover next. Okay. Make sure that you have liked, shared, and subscribed to our channel. And do share it with your friends and family as well, so that they can also get to know about these important topics. Thank you everyone for joining the session. Hope it was helpful. See you this Friday, because this Friday our topic is going to be on contracts related to healthcare and pharma industry. That is a very interesting topic. So I'm hoping to see you all over there. Thank you everyone. Till then, bye bye.